Hi everyone, it's Zarifah Dixon Esquire. Welcome to Z Knows Best podcast, where we talk things all real estate and Wills Trust and Estate. I'm going to be providing valuable information and collaborating with professionals in the field. And if you guys have any suggestions or questions about real estate or Wills Trust and Estate, feel free to drop a comment or send a message. Today, I had the honor of sitting down and speaking with Mr. Michael Bailey, who specializes in landlord tenant law. Thank you, Mr. Bailey, for coming.
Thank you, Z, for having me.
Let's dive right into it. Tell us why you got into law.
I got into landlord tenant law because I was facing eviction before law school, to tell you the truth, and going through that process, and I actually won my case as a pro se, and the court attorney was like, "You should go to law school." But I was already applying to law school at the same time, and my dream job I wanted to do was to work for legal services in Bed-Stuy in Brooklyn, doing tenant defense.
Okay.
Yeah.
Okay. So tell us about the process for landlord and tenants. You said there's a new thing coming out where we're pre-screening tenants. Yes. Tell us about that.
Well, in New York City, it's the landlord tenant market has become real. It's been difficult for landlords in the marketplace for apartments. One, the vacancy rate has dropped tremendously low, so everything is at stake for these apartments now. So we are providing a service where we're pre-screening at a different level than what's typically been done in the space. And what I mean by that is because if you run into a bad tenant, the screening process are for the bad tenants, not the good tenants, right? It's the bad tenants. And a bad tenant is someone that overstays and doesn't pay, right?
Right.
And so what we thought about, what could we do to reduce the amount of time or to quell the ambition of some of these tenants to stay longer than they were supposed to not pay and not pay rent. So what we have is a pre-screening process that provides more protections. And what does that mean? So first of all, we get the new tenants to sign a 1099 form.
Oh,
right. And so
that's different.
So we write to the tenants that you'll sign this 1099 form, and in the event that you overstay or you end up owing for rent and you never paid the rent, we want to be able to report to IRS that you received the economic benefit of whatever amount the rent is. We believe that this will stop new tenants from saying, "Oh, I could overstay," and walk away with no repercussion. Now you have IRS looming over your head. All right?
Right.
In addition to that, we make sure that we get accurate information of the Social Security numbers along with the bank accounts and where the bank accounts are at, just in case we need to do a money judgment at some point because the tenant has left without paying the landlord, right?
So let me ask you, is the tenant now, the new tenant, are they submitting this paperwork through a portal? Is it a person reviewing all these documents? Who is the person in charge to say all right, this is a solid tenant?
Well, what it would be my office doing the reviewing of the application, right? Okay. And making sure that it's a good tenant. They'll submit all the documentation, of course, through the portal, and then we'll review. And that includes the credit check, but it also includes capturing this key information to use later to kind of use as a way to encourage tenants to leave if they're not paying.
Are there any fees associated with it?
Of course, it's a fee, and it's $500 for the entire package. It's basically a kit where anybody, a property manager, a real estate agent, a broker, they could call our office, ask us to clear whatever pool of tenants that they have to see which one is one that's going to likely not that will not breach the lease and will continue to be a good tenant. So we're just looking for the best tenants for our clients.
Okay, I love that. Yeah. Now, let's say you got the good tenant, right? And they sign a lease with the landlord for about a year. What are some of their responsibilities while they're occupying the premises under
for
this
the tenant?
Lease? Yes.
So the tenant, of course, naturally, they must pay the rent when whatever agreed upon date it is. They have to keep the apartment in good conditions.
What does that mean?
It means that they can't cause damage, right?
So what if I want to hang up a painting on a wall or put in a chandelier?
Yeah.
Or recessed lighting? You know, I like my units to be renovated.
Yeah, those are good questions, Z. But the thing is, you can't go ahead and... I call you Z, right?
It's okay, you can call me Z.
So anyway, that's a good question, Zarifah.
You can call me Z. Right, it's okay.
That's a good question, Z. Installing a painting and installing a recessed lights, those are two separate actions, right?
Okay.
Like in most places, yeah, if you put a nail in a wall, it's allowable in most instances in the lease, right? But oftentimes in the lease, it also says like when you remove the painting, you also have to spackle the hole or whatever, repair the hole. If there was any painting that needed to be done over top of the hole, you need to do that because you need to be able to leave the apartment in a condition where it's only normal wear and tear. It's not, it's not you making alterations. Most leases explicitly state that a tenant cannot make alterations. Even if they want to paint, they need to get a approval from the landlord.
Okay. And what about the landlord? What are their duties while we have this 1-year lease?
Well, of course, the landlord duty is to make sure that the apartment doesn't have any housing conditions, any violations. That the warranty of habitability that's implied in all leases. It means that this apartment or this dwelling is suitable for human habitation. And so the New York City laws requires a certain standard that the landlord needs to upkeep in order to satisfy the requirement that the apartment is suitable for human habitation. So that's the main obligation of the landlord.
Okay, so let me ask you this now. Like, let's say you have this 1-year tenant occupying the property, and now the seller decides to sell because they can't maintain it financially. Walk me through that process of how to get this tenant out, the procedure first, and then let's say the tenant's not complying.
So New York City has different type of dwellings that are classified and regulated by separate laws. Mm-hmm. You understand? And so a 1 to 2 family and 1 to 3 family, you don't really need if the lease was expired or you could bring a case, mm-hmm. right?
What if it's not expired? What if it's, let's say, 8 months into the lease? It's a 1-year lease though. Both mm-hmm. parties sign, that was the mutual agreement. The seller says, screw this, I can't do this anymore. I want to move to Florida. But you still have this tenant. So how do you get rid of this tenant legally?
Well, it's really no grounds to get rid of a tenant when there's a lease in place.
Okay.
There are grounds, but those grounds are limited to whether the tenant was a nuisance, chronically late payments, doesn't live there, sublease, so things like that. But if the tenant is occupying an apartment and they're not causing any nuisances, then the landlord wouldn't be able to evict until the termination of the lease.
Okay, so now let's say we're past that year, right? They're occupying the property for like 2 years. They didn't renew a lease after the year. What does that process look like to get the tenant out?
Okay, so in that type of housing, then what would need to happen is that the lease, the tenancy would have to be terminated before you could bring the case into housing court.
Okay. Understand?
And you do that by a notice of termination.
Who sends that notice?
Some agent of the landlord.
Okay.
Right? Preferably a process server. If you ask me, it should be a process server. But it could be anyone, mm-hmm. Just not the landlord.
Right.
You understand? Or anyone that's working for the landlord. So, but someone that the landlord sends on to do it for themselves, to serve is proper. So you serve the notice, and in New York City, if a person lives in an apartment more than 2 years, you got to give them a 90-day notice. Less than 2 years, 60-day notice. If they're squatters, they just get a notice to quit, 10 days notice to quit. And a squatter means that they never had a lease, that they entered without the permission of the current landlord or the predecessor landlord.
Got it.
You understand?
Okay.
And so those are the ways to get the case started. And after you serve the proper notice, then you have to let the notice expire, and then you begin the petition.
So now, when you start the petition, what's that timeline like when we're trying to get this tenant out? Like, again, let's use the example where the landlord is trying to sell their property, and he's like, I'm ready to sell. Like, how long does this take?
So I typically say that an eviction case from beginning to end is about 10 months.
Okay.
I know it's a long time, but in New York City, it's just the nature of the beast, right? Because, look, a tenant is there for more than 2 years. So it's already 3 months, and the case hasn't even started yet. So you got 3 months already, the case didn't start yet, right? The court take about a month to two to give you an index number after you file the petition, which is that's 5 months, and it's not even a court date. The first court date, they give you 45 days. They give the tenant a 45-day adjournment to get counsel. So now we're at 6 months and 15 days, and nothing happened yet.
Sheesh.
And now we're talking about resolving the case.
Okay.
Now, typically, how these cases were approached prior to the pandemic was often the landlord would say, "Look, tenant, I'll give you 6 months to move," and hoping that the case would be resolved in those 6 months. But of course, most of the times the tenants come and ask for more time. That process worked because the trial court was so backed up, and the trial court would have took almost 6 months or more than 6 months, or exactly 6 months. So that was the approach. Because most of the cases are now being settled in that way. The courts now are looking at 6 months. Before, they look at that, that was a generous landlord. He gave him 6 months. Now, because of the nature of the housing market, courts aren't looking at that as like such a generous undertaking by the landlord. Now they're looking at it as, we can add 1 or 2 or 3 more months on your 6 months,
right,
with no rent being paid. So I've changed my approach, whereas one, I ask for rent or use and occupancy on all my holdover cases. You have to do it by motion. Prior to the pandemic, you could just ask the court orally. Now you have to do it by motion. Most attorneys aren't doing that, but they're probably going to change too, especially after they see these videos, D. So we're asking for use and occupancy. So they're paying. It's something to encourage the tenants that, look, you're paying every month. And so we're settling cases with use and occupancy, and it's not 6 months anymore. It's either 3 months, 2 months, and sometimes maybe 4 months. But we're looking for rent, and if they fail to pay the use and occupancy, that's an accelerator. That accelerates. So when we settle our cases, we settle in with judgments of possession already, and we're just staying in eviction until they actually leave the apartment.
Got it. So I have a question for you now. Is there any way to speed up the process? Is there any papers that could be filed? Like I said, if it's a landlord, he's just trying to get up out of here. He can't maintain his property, and now we got this minimum 10-month eviction proceeding pending in court. But he could potentially, his house could go into foreclosure, right?
Yeah.
So is there, in that type of situation, is there any way to try to get the courts to move a little quicker?
There is no way to get the courts to move quicker. Let's start there, right? And the only paper that could make this case move quicker is the green paper, right? That's the paper you're offering to the tenant to vacate.
Yeah.
Which I advise my client. I mean, it doesn't help my office at all, but it will resolve their situation. I'll say, look, like, this case could take 10 months, but maybe 10,000. It used to be 5,000, but that's not cutting the mustard anymore. And it may have to be even more than 10,000. But if that's a business consideration for the landlord to make, whether they have more time than money, essentially. And so that's what I'm advising. So, and I'm also advising when people are in, like, selling, that maybe the 10 months is too much time because you intend to close before the 10 months.
Right.
But I say start the case. So because the amount that you could get at the closing with a tenant in there is going to be less than a vacant. But if you start the case, maybe it'll be half. You know, like 5 months on your side.
Not so much of a loss.
Yeah, 5 months on the owner side.
Got it. Okay, and wrapping it up with landlord tenant court.
Yeah.
Do all the cases go to trial?
No.
Okay.
Most cases do not go to trial. And if a case does go to trial, that oftentimes isn't good for the landlord.
Okay.
You know,
why?
Because it probably means that there's a good defense to the petition. You know, if it goes all the way to trial, unless it's just like a tenant that can't see that, you know, can't connect with reality, like this is inevitable. But oftentimes, if it goes, like I did tenant defense work, so like my cases that went to trial is because they were like good defenses, and 9 times out of 10, the landlord lost those cases.
Okay, I see. So now I want to dive into rent increases.
Yes.
You know, we see it both on residential and commercial.
Yes.
So what is your take on the residential side, and then we could dive into the commercial?
Well, let's talk about residential. One, in regulated apartments that are in buildings that were built before 1974, and they have more than 6 units. Excuse me. You can't just increase the rent to what you want to do. It's based on what the rent guidelines board decided the increase would be, you know. So if you have a rent stabilized apartment, the lease will say rent stabilized, and it will say also the percentage that the rent guidelines board decided for that year. Some years it was 0, and some years it wasn't 0. But that's in a rent stabilized apartment. You can't just make your own price.
Even if everything around you got expensive.
Now, unfortunately, you couldn't do it that way. But if you were a landlord and you said, look, I could no longer operate this apartment at these rents, and the rents be able to maintain the apartment, you could put, and it's a rent stabilized building, you could put in a request, like basically like a hardship. But Department of Housing, Community and Renewal, New York State, DHCR, they would have to make a determination, and they would want to see like your records. They want to see everything to make sure. And in some instances, there are landlords that the rents are so low they can't even operate the building.
Right.
Yeah.
Okay, that's good to know. And then now, what about commercial? Like I'm renting out a storefront.
Okay, let me just say something about the residential non-regulated first, and then we go to commercial.
Got you.
Residential non-regulated, those before you could charge you could charge any percent more.
Was there like a cap?
There was no cap.
No cap.
But it looks like August is coming, and this new good cause eviction law, which I'm still getting familiar with, but it will impact on whether you could make what type of increase you could have. And you understand. So this is going to change what landlords could do, you know.
Do you think it's going to be more of a benefit to landlords? No, it's going to hurt them.
Yeah, because the landlords, you know, most landlords, especially the small landlords, you know, they work hard. They don't really have time to like advocate for their positions. There's no real groups out there. I mean, there are small property owner groups, but you know, they're not like the tenant groups where they push. The tenant groups were pushing for good cause eviction, and they ain't loud. And you know, the squeaky wheel gets the oil, right?
Right.
Yeah. So, and that's the instance here. Yeah.
Okay. And now
commercial is basically a whole different ball game, right? Commercial tenants and commercial landlords under New York City law, they're considered sophisticated parties. Okay. So whatever's in the lease is going to govern. Oftentimes landlords are seeking long-term commercial tenants. So they put a breakdown on each year of what the increase will be. And sometimes it's based on the market rates of, you know, of whatever's going on. They're put in the lease, but oftentimes it's mapped out in the lease.
Is there a cap for commercial units?
No.
Okay.
Yeah.
All right.
And commercial tenants get evicted quicker. It's really all the statutory protections for residential tenants. They don't exist for commercial tenants. Most of them.
Okay, so how do you evict a commercial tenant that's not paying their rent as they would if they were renting out an apartment?
Well, often the lease actually detail how that's going to happen. The more you put in your lease, the more powers you have.
What about, I'm a hairdresser that rented out a storefront for 10 years, and I already established a rapport with the landlord. We didn't feel the need to renew the lease. What happens in that situation?
Well, that tenant could get evicted just with a 30-day notice.
Okay.
30-day notice. And anyway, a commercial tenant anyway could get evicted with 30-day notice unless they say something else in the lease.
Let's talk about squatters' rights. I know there's been a lot of changes with regards to that issue. But first of all, why do they have rights if they're not even allowed to be in the premises?
Well, the squatters' rights go back to common law, and basically New York State and a lot of states, this idea of not letting real property go to waste, right? So this is that's where it comes out of. The body of law, is the bundles of rights that we all learn in all the attorneys learn in property class, right? And one of those rights is a right to exclude, except for if the landlord or the owner of the property is in there to exclude. The laws are just built where it says, all right, we can't wait. So if I, Mike B, stumbled across Z's property and Z is a vacant landlord or absent landlord, right? Then I should be able to use the land and not let it go to waste. So that's where it really comes from, and it's a series of laws, a lot of stuff out of adverse possession and stuff like that. This is all what created this atmosphere for rights for squatters, right? And it was really like, all right, because you're gonna know a squatter's in your property, right. And if you show up in a certain amount of time and you do the right things, you could get them out. But then the system got abused, right? The system built and developed on itself into what we had all the way until the system kind of collapsed on its own, right? The squatter rights framework collapsed on its own, and then the laws changed after a person was killed. I believe it was in Queens. I can't remember, but a squatter and a landlord were confronted, and then a female was killed in that process, I believe. And then so now the law is, prior to that happening, you have to evict the squatter. You have to give the the notice to quit, and then bring them to court, do a petition, and that could take a while, and all of that. So now the law says any person that never had a lease didn't come into the premises on the permission of whether the current or the predecessor landlord is a squatter. And you don't need it says that you don't need a petition, you don't need a notice to quit. All you need to do is call NYPD, and NYPD is supposed to help you get rid of those people. Now, does that create a charge for the squatter? Now they're gonna get arrested for? Well, I'm a civil attorney.
Okay. I hear that. We'll leave that to the criminal attorneys. I don't know. Okay.
See, but what I do know that this is a new development, and it's still, and it's precarious too. Because of one, we're looking at to see how this is going to play out. I've had clients that we're still evicting them the regular way because they try to get NYPD involved, and NYPD doesn't want to get involved. Or I have another case where NYPD came based on that, but then the squatter said, no, we have a lease. Yeah, because if the squatter says,
where'd they get the lease from?
Probably a computer. Probably made it up, But this is the problem right now. These are going to be the issues. Like, all right, so and by the time those cases get to court in that manner, it's going to be like, all right, so a lease in itself shouldn't be able to prove that you actually have a lease. There should also be some other things, but we're not there yet. But at the end of the day, yes, they say you could evict when you could remove, not evict. You could just remove them because they're trespassers. But we're trying to still see how it plays out.
Sounds like a headache. So if you guys have any squatter issues, call Michael.
Yes, please. Please call Bailey Law Firm.
Thank you for coming today again, taking the time out on this beautiful summer day. Appreciate you. And stay tuned, guys.
Thank you, Z.